We'll get started this morning. This is case number 2012-07-1887B, State of Ohio versus Erica Stefanko. Today is June 3rd, 2021. Present today are my bailiff, Tamara Kiefer, my judicial assistant, Kelly Kroll, our court reporter, Christy Gowans, Attorney Easter on behalf of the State of Ohio, James Pollack on behalf of the State of Ohio. We have Elisa, victim advocate, on behalf of the Summit County Prosecutor's Office. We have Kimberly Biggs present with us. She's the mother of the decedent in this case. We have Attorney O'Brien present with us. We have Joelle Hendrick with us. We have Donna Basold with us. We have Attorney Yeager with us on behalf of the Ohio Crime Victim Justice Center. We have GC present. We have Cindy Cobb present. The defendant is present with us from the Summit County Jail. We also have members of the media with us today. So let's start with this. Ms. Stefanko, I know this may sound like an obvious question. I know you met with Attorney O'Brien this morning, but can you confirm for me on the record that you've been able to meet with him prior?
Yes, Your Honor.
Video? Do you agree to conduct this matter by video? Go ahead. I said yes. Is that correct?
I did say yes. Correct.
Okay, thank you very much. So I'm going to mute you to be able to hear. We're set today on defendant's motion for a new trial and mistrial. Attorney O'Brien, before we get started with the substance of the motions, the one thing I'd like to address with our audience here today is, other than members of the media that have my prior authorization, no one has my permission to record these proceedings or disseminate them in any fashion. If I find out that any individual has violated this court order, you could be subject to contempt up to a period of 180 days in the Summit County Jail and a fine of up to $1,000. So with that, we've identified everyone who's present here today. I don't believe that we're missing anyone. I think we've gone through the attendance with everyone. So Attorney O'Brien, is there anything you would like to put on the record before we get started with your motion?
Only that I've had ample opportunity several days ago and this morning to meet with Ms. Stefanko and discuss this upcoming motion.
Okay, Attorney Easter, is there anything you would like to put on the record on behalf of the State of Ohio before we get started this morning?
No, Your Honor.
Okay, Attorney O'Brien, then we'll just note that I'll incorporate by reference your motion into the record. What else would you like to put on the record regarding your motion?
Other than arguing the motion at this point, Your Honor, nothing.
Okay, go ahead. What would you like to put on the record?
Judge, at this point in time, the defense is asking that a mistrial be declared with respect to the trial itself. And should that mistrial be granted, then a new trial would be ordered. Going in chronological order, Your Honor, at the start of the case last November, the court indicated in its tone that the trial would likely last approximately 8 days and that they should be done by the Thanksgiving holiday, which would be the following week. Then chronologically, which I believe gave the jury an expectation that not only should it be done, that it better be done. And with that, Your Honor, the jurors had in their minds the idea that if they were to go past that Thanksgiving holiday itself, then they may be required to come in on the Friday of the Thanksgiving holiday. And if they came in on that Friday, or even if they came in the following Monday, then with the COVID-19 virus being at its peak at that point in time, they would be open to carrying in germs from other people and infecting not only themselves, but other jurors. I would like to add, Your Honor, at that point in time, there were about 10,000 cases a day in Ohio, and approximately 150 people were dying a day. Now, the jury goes out on a Monday and they deliberate for part of Monday afternoon. They deliberate all day Tuesday, and then they come back to continue the deliberation on Wednesday morning. Late on Wednesday morning, the counsel, both the state and defense, are summoned to the courtroom. They are not told, we are not told exactly why we were brought into the courtroom. At that point in time, the court does not indicate to counsel that it was going to give an Allen/Howard charge, but rather launches right into the charge after it hears in open court that there is difficulty, I believe is the exact word, in reaching a verdict. This becomes important, Your Honor, because when the jury does reach verdicts, 4 of the 6 charges Ms. Stefanko is found not guilty of. So it's our contention that had the defense been given the opportunity before the Howard charge is given, or after the Howard charge is given, that this mistrial would not be necessary, and that the defense would have been given the opportunity for giving its input. The counsel never had the opportunity either before the Allen charge or after the Allen charge. I keep saying Allen charge, Judge. I'm old school. When I came on, it was still the Allen charge. I apologize. The Allen charge is a federal decision. The Howard charge is Ohio. Then the court left the bench without inquiring of either counsel if they had anything to say about the Allen charge. And even Mr. LaPrenzi, Miss Easter's lead counsel, he inquired as the court was leaving the bench, was there a note? And that's a quote. And we never received any response to that. So what I'm saying is that this Howard charge had a coercive effect on the jury by implying a sense of urgency to the jury that after 3 partial days of deliberation, it was now midday Wednesday, and that it's before the Thanksgiving holiday. They'd been at this for 8 days in terms of trial and deliberations, and that by late Wednesday afternoon, this was implied a deadline. And so that would take the people that may have been on the fence, push them one way or another. And that coercive effect, Your Honor, deprives Ms. Stefanko of a fair trial. The media was also a factor, not a major factor, but at least a factor. The media is camped outside Judge McLaughlin's courtroom, which at that point in time was being used as a jury room. And that in itself would indicate to the jury that the media was expecting a verdict almost immediately. So what I'm asking the court is, because of the timing, the media, the COVID, that there should have been inquiry before or after the Howard charge, so that we could ensure as to what that Howard charge was going to carry, if we even agreed on a Howard charge. I realize that this all comes under the category of the court having the latitude to to rule in these areas. I'm just saying, Your Honor, that I just believe the process was something of a rush to judgment, and therefore it deprived Ms. Stefanko of a fair trial. We're asking that a mistrial be declared and that a new trial be ordered. Thank you.
Thank you. Attorney Easter?
Thank you, Your Honor. The state understands the defendant's motion and for mistrial and new trial, that his bases are as stated in his motion and as just stated on the record, the giving of the Howard charge without the defense being consulted first, and the defense not having an opportunity to object or ask for a mistrial prior to or after the Howard charge, and the court giving the charge without discussing jury deliberation status with the jury. Also, from the state's reading of the defendant's motion, his basis is that the jurors had undue pressure to reach a verdict based on timing, media coverage, COVID-19 concerns, influenced by the court in issuing the Howard charge. Based on that, Your Honor, the state disagrees for the reasons stated in our motion and for the reasons I'm about to state. In addition, Your Honor, it is well established, Your Honor, and also referenced in the defendant's motion that in Ohio courts, trial courts treat motions for mistrial made post-verdict as motions for a new trial. And we have guidance for motions for a new trial when it should be granted under Criminal Rule 33. In my research on mistrials, though, in general, Your Honor, I found that in determining whether the declaration of a mistrial is proper, the Ohio Supreme Court has declined to apply inflexible standards due to the infinite variety of circumstances in which a mistrial may arise. Instead, the court has adopted an approach which grants great deference to the trial court, the judge, great trial court discretion in this area, and recognition of the fact that the trial judge is in the best position to determine whether the situation in her courtroom warrants declaration of a mistrial. A balancing test is used in which an accused's right to have the charges decided by a particular jury is weighed against the public interest in ensuring that justice is done. Your Honor, in this case, as stated in our motion in opposition, it's well settled that a motion for mistrial should be made at the time of the alleged error, and a motion for a new trial within 14 days after the verdict. In this case, Your Honor, the motion was filed December 29th of 2020. The verdict was November 25th. This motion was filed 35 days post-verdict. It is untimely and should be overruled. In addition, the defendant states that he did not have the opportunity to object or make that motion. The state disagrees with that for several reasons. Throughout the trial, Your Honor, there were times that both the state and the defense stated that we would like to put stuff on the record. And the court had given us that opportunity. If at that time, the defense wanted to object to the Howard charge, post-Howard charge, the defense could have stated that. I want to object. It is the state's position that the court, as throughout the trial, would have given us that opportunity. I don't remember, and please correct me if I'm wrong, the court ever denying us that if asked, we wanted to proffer something or put something on the record, Your Honor. So the state contends that the defendant could have put an objection or asked for a mistrial when and if his alleged error occurred. Also, Your Honor, a basis for the Howard charge, the defense stated, is that it was given without discussing with the jury deliberation status. The first line that the court stated is that the court has been advised that you have indicated difficulty in reaching a verdict. That's a quote. The court put that on the record first. The court acknowledged to the jury that it was aware that the jury was having difficulty reaching a verdict. So the court put it on the record. They were aware and let the jurors know that the court was aware prior to reading the Howard charge, Your Honor. As the state indicated in its motion, there is no requirement that a jury specifically indicate that it is deadlocked before it is appropriate for a trial court to give a Howard charge. Instead, it is within the trial court's discretion, the judge's discretion, to determine whether a jury is deadlocked. Well, in this case, the jury did indicate they were having difficulty reaching a verdict. And based on that information provided to the court, it is reasonable that the court could have reasoned the jury was deadlocked. The Ohio Supreme Court has held that the giving of a neutral supplemental instruction urging the jury to attempt to reach a verdict upon notification by the jury that the court that it was having difficulty reaching an agreement after deliberation with no other circumstances present with the potential of coercion of the jury is not abuse of discretion. And the state argues that there were no other circumstances present. The jurors were not or did not have undue pressure to reach a verdict, as stated in the defense motion as its other basis for the mistrial, new trial, that the jurors had undue pressure to reach a verdict. And I believe some of the things listed by the defense was timing, media coverage, COVID-19 concerns, and full circle with the Howard charge given. The state puts forth that on November 12th of 2020, the state filed a motion for to conduct an all virtual trial, and then the alternative for a continuance if an all virtual trial is not conducted. The defense filed a motion in opposition, so to speak, stating, and I quote, should the court require voir dire to be a virtual process or the entire trial to be a virtual process, the defendant requests a continuance until voir dire and the trial can be held entirely in person. So at that time, the defense wanted to go forward, wanted to have an in-person trial, and the defense was well aware of what was going on at the time, meaning the timing. For an aggravated murder, 1 to 3 weeks is 1 to 3 weeks is normal. Media coverage, defense was well aware that the media was covering this, and the COVID-19 concerns, the defense actually acknowledged how the court was sterilizing and doing everything possible for the COVID-19 concerns. The defense could have requested a continuance and chose not to. Instead, the defense attempts to show that there was potential of coercion of the jury due to alleged pressures because it was the Wednesday before Thanksgiving, as stated in his motion, and today I'm on the record. There was media attention. They were being rushed because of that. The holiday weekend, going home, possibly other jurors being around family members, coming back, and the potential spread of COVID-19 and COVID-19 concerns in general. The state submits that these quote unquote pressures are nothing more than conjecture or speculation. The defendant has put forth nothing as far as affidavits from jurors or any evidence that this is what was on their mind. This is what they were thinking. It's all conjecture and speculation, Your Honor. There is nothing in the record to support the defendant's allegations that the jurors were pressured in any way by the timing of the case, the media interest, or COVID-19 concerns. And as I stated before, with regard to COVID-19, the record shows and counsel acknowledges that the court diligently took measures to disinfect and sanitize the courtroom in accordance with COVID-19 protocols. The bottom line, Your Honor, is that, as I stated, under Criminal Rule 33, which courts treat motions for a mistrial post-verdict as a motion for a new trial, which is governed under Criminal Rule 33, and under the Supreme Court declaration of when a mistrial is proper, the defendant's motion lacks merit and should be denied based on its lack of merit. And that's based on all the reasons the state has enumerated in its motion and today, Your Honor. I can't say enough. Rule 33 lays out the grounds of when and how a new trial should be granted. Rule 33A1, irregularity in proceedings, which the defense attorney touched on. There are none for the reasons the state put forward. And based on 33B, these motions should be filed within 14 days post-verdict. This motion was filed 35 days. So based on the state's arguments today and the state's motion in opposition, the state believes that the defendant's motion for a mistrial and or new trial should be denied, Your Honor.
All right, thank you, Attorney Easter. Attorney O'Brien, anything else?
And still don't mention Rule 33 as the basis for my motion. Secondly, Your Honor, the fact that the jury is read the Howard charge at approximately 11:50 on Wednesday, and approximately 2 hours later, they come back with unanimous verdicts. So I would submit, Your Honor, that alone indicates the pressure that they were under, at least from the court and the Howard charge, let alone the other outside pressures that I indicated both verbally at this motion hearing and also in my motion and my response to the state's motion. So for those foregoing reasons, I would ask the court grant the mistrial motion.
Thank you, Attorney O'Brien. Based on a review of the filed pleadings and the arguments here today, the court denies the motion. The court will issue a journal entry in accordance with its decision. We'll schedule sentencing under separate journal entry. One other matter I'd like to address with the parties is Ms. Stefanko wrote the court a letter. Attorney O'Brien, are you aware of that?
No, Your Honor.
Okay. So my staff has made a copy of the letter that she wrote to me. The court believes it's its obligation to provide that letter to the state of Ohio and to you in your role as her counsel. We'll make certain that copies are made and that letter will be provided today. And then we will schedule a sentencing date forthwith. Anything further from the state?
No, Your Honor.
Attorney O'Brien, anything else?
Nothing, Your Honor.
All right, thank you very much.
Thank you, Your Honor.